When people start thinking about estate planning, doing a will, doing a trust, most of the time they know they need to do something, but they either feel like it's just not high enough of a list on their priority, or I hear a lot of times specifically from younger people, people in their probably in their 30s, maybe even early 40s, who think, I don't have enough, right? What am I going to leave to anybody? And so they're really focused on the asset, on the stuff piece of estate planning. But what I'm when I'm speaking with these younger folks, what I think they miss is it's not just about the stuff if you have young children, right? And I think it's a very different conversation, and often a very difficult conversation, because when you're talking about estate planning for children, or for, I guess, the parent who has young children, it might be the stuff, right? Maybe you've accumulated a house, maybe you have some money in a bank account. But if you have young children, really what estate planning comes down to is worst case scenario. What happens if you and your partner, your spouse, the other parent are traveling and you get into an accident and pass away? Who's going to become the legal guardian of the minor children, of the child? So estate planning, first and foremost, in my opinion, when it comes to young people who have children under the age of 18, estate planning, yes, we're going to talk about who gets what of the stuff, assuming there is stuff. But we're really talking about who would become the legal guardian. Because what happens in most states is, if you have not written that down, typically in a will, but maybe in another similar type of document, if you don't have that written down, if, God forbid, if that happens and both parents pass away, the court is going to step in. There's going to be what's called a guardianship case, and someone is going to be named the legal guardian. It's typically, it's in most people's fear is that they're going to become a ward of the state, and that they're going to have to go to an orphanage or something like that. That can certainly happen, but typically what we see is another person steps up to become the guardian, right? And where we see fighting often is between the in-laws, right? One set of grandparents wants to be the guardian, and the other set of grandparents wants to be the guardian. And now the court's going to decide. Or maybe it's a sibling, or maybe you as the parent don't want any of those people to be the guardian. Maybe it is a close friend. Maybe you don't have a good relationship with your family, or you have a fine relationship, but they have their own kids and they don't have the resources and the means and the time, or they live in a different state, they live in a different country, and you want somebody else to be the guardian. So if that's the situation, then you want to have it written down, because last thing I think most parents want is for there to be, for the child to be in limbo for any amount of time. Is really, any amount of time is too much. And you probably don't want the guardian to be named by the court and ultimately be somebody that you didn't want to be the legal guardian. So again, very difficult conversation. And I would say when I'm doing estate planning for a younger family, it takes a very long time for the parents to decide, because obviously, as myself as a parent, I don't want anyone else to raise my children. I want to raise my child. But it can be, we have to kind of plan for it. And so I think if you're a young parent, or if you're a parent with young children, I guess better said, is something to think about. Again, don't only think about the assets of thinking about the stuff that somebody has, but think about who you would name as the legal guardian in a worst case situation if something were to happen to both of the parents.